Hey guys, today I'm going to talk about why you should have a will. Now, what is a will? A will is a legal document that outlines your wishes about the distribution of your assets and like your property and other important considerations upon your death. If you die without a will, there is no guarantee that your intended wishes will be carried out. Because if you die without a will, it is governed under this thing called intestacy law. You can Google Intestate Succession Act, Section 7. There's a list, there's a table of rules on how a person who dies without a will, his assets is distributed. For example, a married man who does not have any children, who dies without a will, that means dies intestate, half of his assets go equally to his parents and half goes to his spouse. A married man with children, half of the assets will go to the spouse, half equally amongst all his children, and zero to his parents. If a single person dies, then his assets will be distributed equally between both parents, or if one parent is dead, then 100% of his assets to the surviving parents. So why do people do a will? Well, it's because they want to override the intestacy law, the so-called automatic distribution of assets. For example, a husband may not want half of his assets to go to his wife. Okay, he may want 100% or all of his assets to go to his wife. So he does a will to override the intestacy law. Alternatively, a married man with children may not want half of his assets to go to his wife and half to his children. The married man may want to give 10 or 20% of his property or his assets to his parents because of filial piety reasons. In the case of a parent with several children, the parent may not want to distribute their assets equally amongst all their children upon their death. For example, a father has 4 children, okay? His wife has already died. So upon his death, if he does not do a will, his assets will be distributed equally amongst his 4 children. But the parent may not like one of the children because he may be a drug addict, a bankrupt, or has a propensity to squander money away. Or, for example, he may even want to cut away one of the child. So he does a will to cut out one child, disinherit, and then he does a will to distribute his assets among the other 3 children. It could be equally, it could be in different proportions, 50%, 30%, 20%. It's all up to the testator, the person making the will. Also, even if a parent does not want to disinherit or cut out one of his children, because of favoritism of his children, he might want to alter the percentages that each child of his would get each child of his would get upon his death. For example, he has 4 children. He might have a favorite son, so he wants to give the favorite son half of his assets, and the rest 20%, 20%, and 10%. So that's why people do a will to override the intestacy law on equal distribution for a single parent with children. Also, people who are considering a divorce or are currently going through a divorce should do a will to specifically exclude their spouse from the estate. In fact, the will should specifically state that they're excluding the spouse from their estate because they've been separated for a certain period of time, or because they're undergoing a divorce, or because they have caught their spouses doing adultery. Actually, one of my clients, a 29-year-old guy, poor thing, he came to do a will. He was in the midst of a divorce, and he did the will specifically to exclude his wife and to leave everything to his brother. 2 months later, he committed suicide by burning charcoal in his bedroom. He left the will on his bed, and the police confiscated it as evidence. So, if a parent disinherits one or two of the children under his will, the children will not be able to challenge or make a claim under the estate unless he can show that he is disabled. This is provided for in the Inheritance Family Provisions Act. Only a disabled son or daughter can make a claim under the estate of a person if the will does not provide enough for the disabled child. Next, I'm going to talk about LGBTs. You can Google what is LGBTs. Essentially, there are people who cannot get legally married in Singapore. Okay, so in the case of LGBTs, their partners will not be able to inherit any of the assets of their partners unless a will is drafted. So an LGBT may want to draft a will, okay, to leave all his assets to his partner. Alternatively, the LGBT may want to draft a will to leave part of his assets to his partner, some to his parents. It's also common for LGBTs to fall out with their parents because of their orientations. LGBTs may not want the intestate succession laws to apply because if an LGBT dies without a will, both of his parents will get his assets equally. Also, for married couples, a will ensures that the married couples gets to choose the children's legal guardian in the event both parents die before the children are of adult age. This is not possible under intestacy law because under intestacy law there is no will to leave instructions to appoint someone. So you have to do a will to appoint guardians to take care of your children in case both parents die. So what the husband does is the husband does a will saying that if my wife dies first, okay, then I appoint Mr. A as the guardian of all my children. The wife then does a similar will with the same identical clause saying that if my husband dies first and then I die, then Mr. A will become the guardian of all my children. A will also allows you to specify funeral arrangements such as Buddhist funeral arrangements, Taoist, Christian, Catholic funeral arrangements. It allows you to decide, give instructions to your executor on the disposal of your body, for example, that you wish to be cremated, the ashes to be scattered into the sea or to be kept into a niche, in an urn, in a niche at one of the columbariums. Also, a will allows you to make gifts and donations, okay, to charities such as SPCA, Cancer Society, Minds. These are not available under intestacy law because under intestacy law, your assets go to your family members according to the table in the Intestate Succession Act. Now, contrary to popular belief, wills are not just for the rich people. Regardless of how much or how little money you have, you should do a will. Even if all you have is a HDB flat and a bank account with $2,000, you should do a will if you do not want it to be distributed in accordance with intestacy. For example, an old woman, okay, who is not married but who has a few brothers and sisters. She only has one HDB flat, a bank account with $2,000. This old woman may not want the HDB flat to be distributed equally among her brothers and sisters. Even though she doesn't have a lot of money, she should do a will to dictate that upon her death, the HDB flat and the $2,000 in the bank account will go to her favorite niece. This ensures that your assets do not go to family or beneficiaries that you do not want or whom you do not like. So thanks for watching this video on why you need to do a will.